Get ready for the dictation. Start. The scheme under Section 391 of the Companies Act has been very elaborately dealt with by this court in the case of MH Mafatlal versus Mafatlal Industries Limited, reported in AIR 1997 SC 506. From a perusal of the various principles laid down in Mafatlal case, it is clear that the proposed scheme cannot be violative of any provision of law, nor can it be contrary to public policy here. In Hindustan Lever and another versus State of Maharashtra and another, it has been retreated that a scheme under Section 391 of the Companies Act is binding on all shareholders, including those who oppose it, from being sanctioned. It has also been retreated that the jurisdiction of the company court while sanctioning the scheme is supervisory. This court in Hindustan Lever case also accepted the principle laid down in para 29 in Mafatlal discussed above and held that a scheme under Section 391 of the Companies Act cannot be unfair or contrary or public policy, nor can it be unconsignable or against the law. In the case of administrator of the specified undertaking of the Unit Trust of India and another versus Garware Polyester Limited, this court held that a scheme under Section 391 of the Companies Act is a commercial document, and the principles laid down in the case of Mafatlal have been relied upon, and it has been retreated that the scheme must be fair, just and reasonable, and should not contravene public policy or any statutory provision, and has been expressly quoted and approved. Therefore, the main argument of the learned counsel for the appellants that once a scheme under Section 391 of the Companies Act is sanctioned by the court, the same operates as compounding of offence under Section 138 read with Section 141 of the NI Act cannot be accepted. Rather, the principle which has been retreated by this court repeatedly in the aforesaid judgments is that a scheme under Section 391 of the Companies Act cannot be contrary to any law. From this consistent view of this court, it clearly follows that a scheme under Section 391 of the Companies Act cannot have the effect of overriding the requirement of any law prevailing in the country now. The compounding of an offence is always controlled by statutory provision. There are various features in the compounding of an offence, and those features must be satisfied before it can be claimed by the offender that the offence has been compounded. Thus, compounding of an offence cannot be achieved indirectly by the sanctioning of a scheme by the company court. The learned counsel also relied on a few other judgments in order to contend the scheme of compromise operates a statutory consent, and the same will have the effect of restructuring legally enforceable debts or liabilities of the company. In support of the said contention, reliance was placed on the judgment of this court in the case of Balmer Lorry Workers Union, Bombay and another versus Balmer Lorry and Company Limited and others. That decision related to a settlement reached in a proceeding under Industrial Disputes Act in which a representative union was a party. The court held that such a settlement is binding on all the workmen of the undertaking. This court fails to understand the application of this ratio to the facts of the present case. Reliance was also placed by the learned counsel for the appellants on the decision of this court in the case of S.G. Baswanti versus L.V. Textile Mills and others. In that case, also the question of an agreement under Section 18 of Industrial Disputes Act came up for consideration by this court. The wide sweep of an agreement under Section 18 of the Industrial Disputes Act for the purpose of maintaining industrial peace is not in issue in this case. Therefore, the decision in the case does not have any relevance to the question with which we are concerned in the facts and circumstances of the case. The learned counsel for the appellants then advanced his argument on the provisions of N.I. Act and the nature of the offence under the N.I. Act. Reliance was placed on explanation to Section 138 of the N.I. Act in order to show that for the purposes of an offence under Section 138 of the N.I. Act, debt or other liability must mean a legally enforceable debt or liability. The learned counsel urged that even if a check is issued by the appellant company and which has been subsequently dishonored, the same is a check relating to the debt of the company in respect of which there is a sanctioned scheme. Therefore, the same is not a legally enforceable debt inasmuch as after the sanctioning of the scheme, the debt can only be enforced against the company by a creditor stop.